Once upon a time, two minds clashed. Words went after words, thoughts went after thoughts. Accusations got out of hand and could only be calmed with a document, the Bill of Rights. Though some were against the idea, stating that the bill would be a parchment barrier, many were for it and came together for the first draft. In 1791, the Bill of Rights was ratified into the Constitution and changed the course of American history forever. In 1868, the 14th Amendment was ratified. In the first section of the 14th Amendment, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. In short, all persons have equal rights and shall not be limited by any law.
14 years before Regents v. Bakke, in 1964, Lyndon B. Johnson put his ink signature on the Civil Rights Act. It was a turning point of American history. It was the next step after the 13th Amendment and Plessy v. Ferguson for the fates of other races besides Caucasians. It was this Civil Rights Act that prompted a war of words. It was the Civil Rights Act that also spawned support for the idea of affirmative action, which was a relatively new concept during that time. It was just newly introduced in the 1960s. Affirmative action is policies that relate to injustices toward race, ethnicity, gender, national origin, etc. It is affirmative action that spawned this case, Regents of the University of California v. Bakke. But before we delve into Bakke, we must first investigate 7 cases. Plessy v. Ferguson, 1895, Hirabayashi v. U.S., 1943, Kurematsu v. U.S., 1944, Brown v. Board of Education, 1952, Hernandez v. Texas, 1953, Green v. County School Board, 1968, and Board of Education v. Swan, 1970. The first case we shall look into is Plessy v. Ferguson. This case was one of the first landmark racial segregation cases for the history of the country. It is about a man 7/8 Caucasian sitting in an all-white section. The case's final result ends shockingly for the modern-day integrated society. Ferguson, the all-white train conductor, won. Plessy would still have to sit in the segregated African-American section. This had a huge impact on Regents of the University of California v. Bakke as it drew major attention to segregation. The second case, Hirabayashi v. U.S., the predecessor and lesser version of the famous Korematsu v. U.S., detailed removal of a certain citizen, Hirabayashi, based on his descent, Japanese, for military reasons. The court sided with the U.S., claiming that Hirabayashi must be removed from the area as the president's orders of removing Japanese citizens did not violate the Fifth Amendment. It was Hirabayashi's case that highlighted the fact that rules and restrictions completely based on the race or origin of someone could not be abided by a free people. After Hirabayashi v. U.S., the landmark case of Korematsu v. U.S. made its way to the Supreme Court. It debated just about the same question as Hirabayashi. Did the President and Congress have the power to restrict rights and exclude people from a certain area based on their descent? In the end, the Supreme Court, just like in Hirabayashi, claimed that it was perfectly constitutional to do so and that they held the right to protect against espionage. This drew attention of the Supreme Court to the fact that legal restrictions needed to be inspected closely when they involved certain races. The next case after Korematsu was the ultimate segregation case, the 5 cases that made up Brown v. Board of Education. It involved students that were African American getting rejected by schools for Caucasian students. The result affected the fate of segregation in the school system ever since. Segregation is unconstitutional, so therefore should be banned. 1953's Hernandez v. Texas details a Mexican-American man named Pete Hernandez who is tried by an all-white court for the murder of someone else. Hernandez appealed that it was a denial of the 14th Amendment when they tried him in front of a jury that was excluding his particular race. Hernandez won the case unanimously and acted as a precedent for Bakke in where the 14th Amendment does not solely apply to African Americans and Caucasians, but other races too. Another case that left a statement on Bakke was Green v. County School Board, 1968. This case talked about whether a student was able to choose his own public school with freedom of choice without being ranked by his race. Green won, but this idea of free transfer, as it was called, was an ineffective way of battling segregation. The decision affected Bakke, where public institutions that had been associated with racial discrimination cannot merely end its illegitimate acts and act neutrally to be in ordinance with the Equal Protection Clause of the 14th Amendment. Another case that left a statement on Bakke was Green v. County School Board, 1968. This case talked about whether a student was able to choose his own public school with freedom of choice without being ranked by his race. Green won, but this idea of free transfer, as it was called, was an ineffective way of battling segregation. The decision affected Bakke, where public institutions that had been associated with racial discrimination cannot merely end its illegitimate acts and act neutrally to be in ordinance with the Equal Protection Clause of the 14th Amendment.
The Medical School of University of California at Davis opened in 1968 with an entering class of 50 students. 3 years later, the number of students increased to 100. No special program was created for the disadvantaged and minority students. In the opening class, there were only 3 Asians, but no Blacks, Hispanics, or American Indians. In the early 1970s, the Medical School of the University of California at Davis created a dual admissions program to increase the representation of minority students. Originally, set requirements were used to decide who was accepted and who was rejected. For example, if an applicant fell below a 2.5 grade point average, they were automatically rejected. From the remaining students, some would be picked to go through interviews. The admissions committee rated the candidates who survived the screening process on a scale of 1 to 100. This rating included the interviewer's evaluation, the candidates' overall science and grade point averages, scores on the MCATs, letters of recommendations, extracurricular activities, and other biographical information. The ratings would add to make the benchmark score. The special admissions program worked with a committee that had a majority number of members belonging to minority groups. They considered the minority group to consist of Blacks, Asians, Hispanics, and American Indians. Since there was no exact definition for the disadvantaged group, the committee decided, based on the applicant's background information, if they were considered to be qualified for the program. Included in the application was an area that indicated what ethnic group they were and whether they were economically and/or educationally challenged. These applications were sent to the Special Admissions Committee to determine whether the candidate met the criteria for minority and disadvantaged groups. They did not have to meet the regular requirements. During the years of 1971 to 1974, the dual program resulted in the admission of 63 minority students, whereas the regular admissions admitted 44. Alan Bakke was a white male who applied to the Davis Medical School in both 1973 and 1974. His interviewer, Dr. Theodore C. West, stated that Bakke was a very desirable applicant to the medical school. Even with a strong benchmark score of 468 out of 500, Bakke was rejected. This was partly due to the fact that his application was completed late in the year, and no applicant with a benchmark score of 470 and under was accepted when Bakke's application was completed. During that time, there were 4 special admission spots still left to be filled. However, Bakke was not considered to be disadvantaged, so he was not qualified for the program. After his rejection, Bakke wrote a letter of complaint to the Associate Dean and Chairman of the Admissions Committee, Dr. George H. Lowry, protesting that the special admissions program was used as a racial and ethnic quota. Bakke's second application, filed in 1974, was completed early in the year. His student interviewer found him to be friendly, well-tempered, conscientious, and delightful to speak with. His student interviewer gave him a high rating of 94. His faculty interviewer, however, happened to be no other than the same Dr. Lowry that Bakke had written a protest to. Dr. Lowry found Bakke to be rather limited in his approach to problems in the medical profession and gave him an 86, the lowest rating of the 6 he gave out. Bakke ended up with a 549 of 600. Again, Bakke was rejected. During those years, minority applicants with lower benchmark scores were admitted to the medical school under the special admissions program. After a second rejection, Bakke filed suit in the Supreme Court of Yolo County, California, for the violation of the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964 for admission based solely on race. The court eventually agreed with Bakke, stating that the university did in fact violate the federal and state constitutions and was therefore illegal. The court ruled that Bakke should not be admitted into the school because it failed to show why he should be admitted. When the university appealed to the Supreme Court of California, the special admissions program was also determined unconstitutional. The Supreme Court of California stated that no applicant may be rejected because of his race, in favor of another who is less qualified, as measured by standards applied without regard to race. The medical school was ordered to shut down its quota system. However, unlike the Court of Yolo County, the Supreme Court of California ruled that Bakke should be admitted because the university failed to prove that Bakke would not have been admitted without the special admissions program. The case was then appealed to the U.S. Supreme Court, who reviewed the case in 1978. When Bakke filed suit, numerous amounts of protests came from around the nation, stating that if Bakke wins, then everyone belonging to the minority and disadvantaged groups would lose employment, education, and housing. A group called the Anti-Bakke Decision Coalition was formed and led protests before the federal courthouse in Foley Square, New York, on June 30, 1978.
The university's legal matters were led by Archibald Cox, who was also a special prosecutor of the Watergate scandal. The legal team supported affirmative action. Cox wrote that, quote, "The outcome of this controversy will decide for future generations whether blacks, Chicanos, and other insular minorities are to have meaningful access to higher education and real opportunities to enter the learned professions." On Bakke's side, Reynold Colvin stated that Bakke had his rights under the 14th Amendment to Equal Protection, and that the special admission program had violated these rights. The consideration of this case began under the authority of President Jimmy Carter. At this point, the United States had filed a brief through Cox that supported affirmative action, but also stated that the special admissions program should be taken down and Bakke admitted. This brief was an amicus curiae, which means that it was written without solicitation from either party in court. The brief supported programs made to compensate for past discrimination, but was against rigid rejections. Oral argument took place. The public was very interested in the case, and many attended the court session. The session took 2 hours, with Cox arguing for the university, Colvin for Bakke, and Wade H. McCree for the United States. The university argued that Title VI did not account for private plaintiffs, such as Bakke. Colvin argued that the university was a discriminatory institution. After analyzing the minority admissions program, Justice Lewis Powell determined that affirmative action was allowed under certain circumstances. To put it basically, this case tore apart the Supreme Court. A total of 6 opinions were formed from 9 justices, none of which who had the full support of the court. Overall, 4 justices, including the Chief Justice, favored supporting the California Supreme Court's decision. 3 justices supported the program. Justice Blackmun was on leave to have prostate surgery. Justice Powell withheld his opinion. When Justice Blackmun returned, he joined the group supporting the program, making the opinions 4 justices against 4 justices. As a result, the verdict rested on Justice Powell's decision. Justice Powell released a plurality opinion to deliver the judgment of the court. 4 of the justices agreed in that the minority admissions program should be removed, and Bakke's admitted. The other 4 justices dissented from that, but they agreed with Powell in that affirmative action is permissible in some cases, and reversed the judgment of the California Supreme Court that prevented the university from considering race in the admissions process. Justice Lewis Powell concluded several things. Title VI only prevents racial sorting that violates the Equal Protection Clause when it is used by state or its agencies. Any kind of racial or ethnic classifications require specific analysis by the judiciary branch. It is a good cause to try to enroll a diverse student body, so including race in admissions programs is justifiable, if it is considered alongside other factors. However, in this case, barring consideration of people like Bakke isn't necessary to achieve student diversity, and thus invalid under the Equal Protection Clause. Justice Brennan, Justice White, Justice Marshall, and Justice Blackmun agreed with the previous points. Justice Powell also concluded that since the university could not prove that Bakke would not have been admitted even without the special admissions program, he must be admitted. Justice Stephen, Chief Justice Berger, Justice Stewart, and Justice Rehnquist had the following view. The issue is not whether or not race should be a factor in the admissions. Bakke was excluded from the university in violation of Title VI and should be admitted. It was determined that the medical school racially discriminated against whites because it included them from 16 out of 100 spots solely by the principle of their race. The history of blacks being discriminated against more than whites does not matter because any sort of racial quota is against the principle of equality. Although the school system was trying to account for past discrimination, it only created another type of judgment based on race. In conclusion, racial quotas are always unconstitutional, but affirmative action programs may be constitutional if race is considered as one of many admissions factors and used to remedy past findings of discrimination and to promote diversity.
The landmark case of Regents of the University of California v. Bakke left a huge impression on the school system in general, along with other cases after that. Significantly, the 4 cases of Wygant v. Jackson Board of Education, 1985, Hopwood v. Texas University Law School, 1994, Grutter v. Bollinger, 2002, and Gratz v. Bollinger, 2003. Wygant v. Jackson Board of Education is about the use of affirmative action when firing teachers. Wendy Wygant, a Caucasian teacher, was fired and the minority teachers with less seniority were not. She brought her case to the Supreme Court and won in a tight deadlock of 5-4, where the Supreme Court claimed that societal discrimination was not enough of a legitimate reason to sway the rights of innocent citizens who had done no wrong in the workforce or in society. Bakke helped determine that affirmative action only goes to certain extent. The 1994 case of Hopwood v. Texas University Law School was very similar to Bakke, but it did not make it to the Supreme Court, instead ending in the District Court of Appeals, with a different result. It told of a student, Cheryl Hopwood, who, like Bakke, was rejected for a more racially diverse student body. The case's final decision suspended the university's affirmative action program and overruled the Bakke decision, and hereafter, Louisiana, Texas, and Mississippi all abide by the Hopwood decision. Grutter v. Bollinger and Gratz v. Bollinger were 2 very similar cases that involved the admissions program of the University of Michigan. The former about the law school and the latter about the literature, arts, and science program. The result of a 5-4 split tie, as written in Sandra Day O'Connor's majority opinion, was that the Supreme Court accepted the affirmative action process for the University of Michigan to maintain a diverse student body and allowed them to continue using it. However, one idea also stood out. This policy was not to stand after 25 years after the case. So the University of Michigan will have to fork over its policy in the year of 2027 along with other liberal arts colleges.